supplement the issue that we need to work through concerning the foundation. Do you have the witness available to do this proffer?
Yes, Your Honor. Judge, you have a copy, that is actually the copy of State's Exhibit 60 on the bench. I provided copies to the defense as well. This contains all of the divorce documents that the defense objected to last week with Detective Isom. It includes one additional pleading, the grandma motion, as it's been referenced previously. That's tab JJ in your book there. So each tab represents a divorce filing, and behind the divorce filing in each tab is the supporting documentation for that document to show that Donna Adelson was aware of that particular pleading. So the state is going to be seeking to introduce this exhibit. My understanding is the only issue in contention at this time is the JJ tab. So we will call Investigator Newlin at this time to address that issue.
Investigator Newlin, if you can come up and take the stand. Please raise your right hand to be sworn for proffer. Do you swear or affirm the testimony you're about to give is the truth? I swear. You may take your seat. You may inquire, Ms. Kappelman, when you are ready.
Thank you, Judge. I just need about 30 seconds.
Deputies, if we've run out of seating room, is there an overflow area? Turn those funds off, please.
Sir, please introduce yourself and spell your name.
My name is Jason Newlin, Jasonnenewlin.
How are you employed, sir?
I'm an investigator with the State Attorney's Office here in Tallahassee.
Were you asked to assist in assembling the notebook that's known as State's Exhibit 60?
Yes.
And does State's Exhibit 60 contain each of the divorce filings that we were able to directly link to Donna Adelson, meaning show that through some other means that she had knowledge of those pleadings?
Yes.
And is the book organized such that each tab has the pleading, and then right behind that tab will be the supporting documentation associated with that tab?
That's correct.
All right, I want to draw your attention to tab JJ, which specifically contains page 441 through 456 of Dan Markel and Wendy Adelson's divorce pleadings. This is a pleading entitled what?
Former husband's counter motion for enforcement of MSA on parenting issues and motion for contempt and sanctions.
And is this the motion that we have referred to throughout preparation for this trial as the grandma motion?
Yes.
Is that because this is the motion in which Dan Markel is seeking to limit or restrict Donna Adelson's contact with his children?
Yes, it is.
Okay, so the language, grandma says that the kids are reporting to him, grandma says you're stupid, that sort of thing, that's what's in this motion?
That's correct.
Okay. And on what date was this motion filed by Dan Markel?
March 26, 2014.
Okay. And is there an email predating that filing in which Dan Markel sends Wendy Adelson the content of what ends up in this motion, the allegations that end up in this motion, and outlines them for her?
Yes.
And was that email forwarded to Donna Adelson?
Yes, it was.
On what date was that email forwarded to Donna Adelson?
December 17th, 2013.
And is that email contained in State's Exhibit 60JJ.2?
Yes, it is.
Right, and was there a response to Wendy forwarding this stuff to Donna?
Yes, there was.
And what was the response?
Wow.
All right, and is there another email the next day in which Wendy forwards the parenting coordinator's response to Dan's allegations of grandparental alienation?
Yes, there was.
All right, and is that what the email that's marked as JJ.3?
Yes.
And this is the one that, for some reason, when we print it out, comes out in a big, weird formatting block?
Yes.
Okay, but this email was sent from Wendy to her mother?
Dear Mom and Dad. Yes.
Okay, and on what date?
December 18th, 2013.
Okay, and that's addressed Dear Mom and Dad.
That's correct.
And that contains the same allegations that are later contained in State's Exhibit JJ.
Yes.
Okay. And when the motion was actually filed on 3/26/14, do you have any evidence as to where Donna Adelson was located at that time?
Traveling to Orlando on her way to Tallahassee, Florida.
All right, so she wasn't forwarded the actual motion.
Not that we
Right.
can tell.
Okay, and is that
One
consistent?
moment. Turn off the phone. Please continue.
And is her presence in Tallahassee when the motion was actually filed, or actually she was on her way at the time it was filed, consistent with why she might not have been forwarded that exact pleading when she was forwarded other pleadings?
Correct.
Right. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor, thank you. Good morning.
Morning.
The email JJ2 that is dated December 18th of 2013, that was sent to an email address shared by Donna Adelson and Harvey Adelson, correct?
Correct.
You don't know who responded wow, do you?
I do not.
And with respect to Donna Adelson driving from Orlando to Tallahassee at the time that the motion was filed on March 26, 2014, you don't have any evidence that that motion was shared with Donna, do you?
No.
Nothing further?
Going to redirect for Investigator Newlin.
In the research you did on all the filings preceding JJ, were many of those sent to the shared email address donnaharvey@gmail.com?
Most of them, yes.
Okay, and in many of those, does Donna respond in a way that we can confirm that it's Donna Adelson responding as opposed to Harvey Adelson?
Wow was a common response from many emails signed Love Mom.
Right, but my question is, in a lot of them, do we have a pattern of Donna responding to those emails?
Yes.
And we have a pattern of her doing so such that we can say this one is Donna, not potentially Harvey.
That's correct.
Objection calls for speculation.
Overruled, but if he is aware of the pattern for his investigation, he may testify confidently on this point.
Meaning they're signed Mom,
Yes.
or they say Dad and I, whatever, with context indicating Donna's the author as opposed to Harvey.
That's correct.
Nothing further, Judge.
You may step down, Investigator. Any other witnesses or evidence to offer concerning the issue of the proffer?
No, Your Honor, not all we're learning about is that tab.
Mr. Zeldin, you may make any final argument concerning JJ of State 60.
Thank you, Your Honor. Your Honor, it's the defense position that the state's argument is entirely speculative. In Investigator Newlin's testimony, he indicated that the pattern indicated that when Donna was responding to these emails with pleadings, she would sign it with her name, or she would indicate Dad and I. This response, JJ2, just says wow exclamation point. As a result, Your Honor, it's our position that the state cannot establish a foundation for admission of JJ1, which is the March 26, 2014 counter motion that the state has nicknamed the grandmother motion.
Scott, hold on, you may briefly respond.
Judge, the email was sent to a joint email that we can prove was routinely checked and responded to by Donna Adelson. She routinely checked and responded to emails specifically in reference to this divorce, and the pattern and totality of the testimony will show that she was the one that was primarily engaged in receiving pleadings, giving feedback on pleadings, even drafting and editing pleadings on Wendy's behalf. So I think the fact that the email was shared, and if the defense wants to point that out and argue that maybe it was Harvey that responded to this particular email, then they're free to do that. I think that goes to weight, not admissibility. I think it's important that the second time the email was shared, it was directed to Mom and Dad, meaning it was specifically directed to Donna and Harvey, so not just to Harvey.
The foundation for this item will need to be established. It sounds through multiple witnesses, both Investigator Newlin and also through the testimony of Wendy Adelson. However, once the pattern has been demonstrated, I will find, based on this can be admitted if the pattern in fact does show that both either Donna Adelson or Harvey Adelson would both respond from this email concerning matters of the divorce, and the communications do in fact match other communications that were made specifically by the defendant. Concerning the limiting instruction that was discussed on Friday, if the defense is still seeking this, the court would provide the instruction. This evidence may be considered for demonstrating state of mind, motive, or intent, unless you're seeking some other form of limiting instruction, specifically as to 60 JJ.
Just a moment, Your Honor. Read that to us again, please.
This evidence may be considered for demonstrating the defendant's state of mind, motive, or intent as far as any arguments that Donna Adelson is in fact not the person who sent the wow response because it was shared. Certainly the defense is free to cross-examine on that point and present any evidence or argument in support of that position. But I am going to find that these matters being argued go to weight, not admissibility, if the pattern can be demonstrated by both the investigator and Wendy Adelson and their knowledge of these communications or investigation.
That's, defense appreciates that and agrees with the language.
Very well. Ms. Keppelman, do you wish for State 60 to remain at the bench, or will you need it back for the moment?
I have a copy, Judge, so if you'd like to keep it for your use, that's fine, or I can retrieve it.
All right, I will just keep it up here then next to my trial notebook. Are there any other matters that we need to address before the jurors are brought in for this morning?
No, Your Honor.
I believe, as previously discussed before last week on Friday, as it relates to Wendy Adelson, if the defense is still seeking to take a proffer as to matters that would be both relevant and would not, at least in their review of the evidence go to Mrs. Adelson's Fifth Amendment privilege. I will allow you to take a proffer out of the presence of the jury concerning that matter. Is Mr. Loro present so he understands what will take place?
I don't think he's present, Judge. I think I told them 10 o'clock.
All right. When it's time for her to take the stand, she will be testifying pursuant to the state subpoena and any immunity that would attach under the state subpoena. After that examination has concluded, the jurors will be taken out of the room so the proffer can take place. I believe Mr. Loro's position on this matter has been clear throughout. As to anything but a state subpoena which confers immunity, he or his client intends to invoke her privilege against self-incrimination. As to that, he will be informed of the defense being able to take a proffer, since the proffer was not possible at the time the motion was argued. Again, depending on what the questions are and whether she will still intend to invoke the privilege at that time, the court will make a ruling. I did, though, want to make sure both parties are aware as it relates to the cases on the invocation of the privilege under federal law and both state law. The defense is going to have a high hurdle to clear with this. I believe cases go to the lines of the privilege not only protects the answers that would in themselves support a conviction under a federal or state criminal statute, but likewise embraces those which would furnish a link in the chain of evidence. And to that point, I believe that is where Mr. Loro's argument lies. But Mr. Zellman, again, you'll have your opportunity to make your proffer to determine whether in fact there is something that is relevant and does not go to the proper invocation of the privilege.
Yes,
All right. While we're awaiting the jurors, I believe we told them to report at 9:15. If there are any needs that the parties need to attend to, please do so now. If anyone needs to use the restroom, please do so now. Once the jurors arrive, we will bring them in and we'll get started with our first witness for the day. Does either party need to be heard about this any further?
No, Your Honor. You'd like to start at 9:15?
9:15, I believe that's when the jurors were told to report.
Thank you, Your Honor.
Still no going out and doing testimony.